Post-employment restrictions. Prohibition on switching sides. After leaving the city, you may not represent any other person or entity in a transaction where the city is a party if you have worked personally and substantially on a particular matter. A particular matter may include a contract, grant, permit, or similar transaction. For example, a city employee, as staff to a council member, advised the council member regarding a particular city contract that went through city council for approval. The city employee, upon leaving the city, may not represent or communicate on behalf of the contracted company in relation to the city on that contract, or even advise, assist, or consult the company as it relates to the contract. The prohibition is permanent, but limited to the particular matter, which in this case is the specific contract. 1-year lobbying ban. For 1 year after termination of your employment or service with the city, you may not communicate with your former department or board with the intent to influence a government decision on behalf of another person or entity. For the mayor, city council members, and their senior staff, the 1-year lobbying ban extends to all city departments. For example, after her term expired, a former commissioner of the Children's Fund, Planning and Oversight Commission, took a position as director of a local nonprofit that provides youth services in Oakland. The former commissioner cannot lobby her former board for a period of 1 year. Going to work for a contractor. You may not accept employment or pay from a person or entity that entered into a contract with the city within the preceding year where you personally and substantially participated in the award of that contract. For example, a city employee participated in the awarding of an IT contract with a vendor. He leaves his city job and is offered a job working for the vendor. The former city employee cannot be employed by or otherwise receive compensation from the vendor for 1 year after the city employee's participation in the contract. And note, it doesn't matter that you weren't thinking about your next job at the time you were working for the city or that the job was offered to you after you left the city. If the legal test is met, it is a violation of the law. Influencing prospective employment. A public servant may not make, participate in making, or otherwise seek to influence a governmental decision affecting a person or entity with whom the public servant is discussing, negotiating, or has entered into an agreement concerning future employment. In other words, you can't impact a decision about a company with whom you have submitted an employment application. For example, a building inspector cannot approve a commercial development permit for a company at the same time he is applying or discussing employment with that company. While a public servant cannot influence action regarding a future employer, the public servant also may not influence approval or a decision on a contract that involves the public servant's former employer, if within 1 year of the public servant having worked for that employer. Conflicts of interest are important to protect the actual and perceived integrity of city government to ensure that the public's interest is protected. Contact the PEC for advice if you ever have a conflict of interest question. Rick, a department director, and Veronica, a vendor, are negotiating a new contract between her company and the city. They chat about the details over dinner. Veronica mentions that her company has been impressed with Rick and wants to interview him for a job. Rick goes on the interview. Is this okay? That is correct. In order to avoid violating the law, Rick is prohibited from pursuing a job offer with any company with which he is actively working with on his city job.